AB 2542, or the Racial Justice Act, which came in effect on January 1, 2021. The law prohibited the state from obtaining or seeking to obtain a criminal conviction or imposing a sentence on the basis of race, ethnicity, or national origin. The landmark law was a step in the right direction and was welcomed by criminal justice reform advocates. Prior to the passing of AB 2542, proving racial biases was almost impossible. In short, the court required defendants to prove intentional discrimination and held that statistical disparities are not enough to show constitution violation. And unfortunately, for all the good AB 2542 aimed to do, it still left thousands of people behind, as it applied only to people who were sentenced in the trial court after January 1st of 2021. However, thanks to AB 256 and thanks to the organizations that played a big role and sponsored it, like the American Civil Liberties Union, ACLU, American Friends Services Committee, AFSC, California Coalition for Women Prisoners, Californians for a Responsible Budget, Coalition for Human Immigrant Rights, Ella Baker Center for Human Rights, Initiate Justice, the League of Women Voters of California, Next Gen California, and Silicon Valley Debug. They were able to come up with the Racial Justice Act for All, which will make the RJA apply retroactively, which means it will apply to people who are sentenced before January 1, 2021. But the AB 256 will become retroactive in stages. So I'm just going to break down the stages that it will become, how it will become retroactive. So already January 2023, people sentenced to death or facing possible immigration consequences like deportation. And then next year, January 1, 2024, people in prison in county jail serving a sentence for a felony conviction or in the Division of Juvenile Justice, or DJJ, will be eligible. And then January 1, 2025, people no longer incarcerated, but with a felony conviction or a juvenile case that resulted in commitment to DJJ entered after 2015 will be eligible. And then in January 1, 2026, anyone with a felony conviction or a juvenile case that resulted in commitment will be eligible. But there are some specific steps and some specific claims that folks should look for when it comes to their case. So I'm going to pass it over to Brooke, and Brooke's going to be able to break it all down to y'all.
Thanks again for having me. So what I want to give everyone is both the law, but also kind of a realistic guide moving forward. This is obviously a new law. There are a lot of attorneys that are spending their entire day, every day, trying to figure out what the law means and how the courts are going to apply it and everything. So just know there are still a lot of questions. We, of course, have resistant courts all across the state. Doesn't matter what county you're in. We have resistant DAs. We also have courts that want these claims and DAs that want to help. So it really just depends where you're at. And so nothing we say is going to be like, oh, that definitely applies to my case, or this definitely doesn't. We're always going to say, if you can, get an attorney, obviously, but being realistic, not everyone's going to be able to do that. And so what are the best steps forward? One thing I want to flag is that there was another amendment to this law that will be effective January 1st of 2024 that clarifies the ability of someone to raise these claims on direct appeal. So this would apply if your loved one maybe has gone back to court for another resentencing, to strike their nickel prior or some other relief, and maybe they're appealing from there. There is a possibility they then would be able to raise RJA claims that came up in their resentencing on that appeal. But for most people, what we are realistically looking at is post-conviction relief or habeas proceedings. And so for those, individuals, there's 4 different kind of categories of claims. If you're talking to a lawyer, they're going to shorthand them as A1, A2, A3, or A4. And so just in terms of getting yourself prepared, if you're going into a meeting with a lawyer, that's going to be the shorthand. I'm going to walk you through kind of each one. So A1, the reason it's referred to that is just the subdivision of how they categorize each paragraph in legislation. There's no actual significance to it. So A1 is that a judge, attorney, law enforcement officer involved in the case, expert witness, or juror exhibited bias or animus. So what this tends to be, A1 tends to be a situation where you have an off the record, maybe out of your trial situation. Like right now, of course, there's a bunch of scandals going on with officers sending really racist text messages in various counties, right? So if you can connect a person who took place or who participated in like the criminal proceedings, whether that's trial or maybe plea or the investigation, and you can show that they have bias towards your loved one's race, then you'd be able to bring an A1 claim. Now, an A2 claim is in some ways where families can be most impactful. So an A2 claim is an on the record claim is what we call it. Meaning if I, as an appellate attorney, say, give me every word that was said in this trial, give me the transcript, I will be able to see it on its face. It will be right there on the paper, okay? These in some ways are the cleanest, also complicated because when we type things out on paper, they don't have tone, inflection, etc. And so those are all obviously changes in how a court will read it. But for an A2 claim, it says, while we were transcribing, while we were on the record in this case, again, judge, an attorney, an officer, an expert witness, or juror used racially discriminatory language or otherwise exhibited bias or animus. And this is where families can be helpful because attorneys, especially in smaller counties, do not have money to go back and review your loved one's case. In some counties, they do. And that's why we're going to start off by saying, reach your county public defender, and people will talk about that later of how to do it. But this is where reviewing the transcripts, if you're like, oh, you know what, they kept using, they kept emphasizing how we said police instead of police, right? Or they were talking so much about how like, oh, he's an immigrant and then he was using his child to work, but that's like culturally something that that community does. These are examples from actual cases where attorneys or judges or an officer have said something on the trial record that is problematic. And sometimes when you're reading that plain trial transcript, you're not going to have all of this context, right? Especially like an appellate attorney or an attorney who's looking at an old case. They won't always know like what's the political climate that was happening when your loved one went to trial, right? What was it, a time of particularly anti-immigrant bias? Was it a time where there was a lot of issues around police brutality and your loved one got caught up in like an assault on an officer and it felt a little bit like retribution on part of the government? All of those context clues are going to be really helpful. And so when you read through your loved one's transcripts, you want to look for language that you, as someone who's close to your loved one who maybe shares that identity, that didn't sit right, that they were using that in a way to try and other your loved one or to show they were dangerous or to make them non-human in some way, right? Because that's what a lot of this language gets down to. Or if you're like, oh, they were just throwing around the N-word, even when they weren't referencing like a witness said the N-word, probably want to flag that. Other, derogatory words, descriptions, etc. You want to go through and note that. And what I would recommend is if you can try and kind of highlight and kind of like write up in a short summary, like this is the language that I think was wrong. This is why, if you know, like in our community, that term is used in a derogatory way, or because of like the politics at the time that were happening, etc. Try and explain that. I just saw in the chat, what if the remarks are made by police in police interrogation transcripts prior to trial? That is going to be an it depends, and a lot of our answers will be it depends. So that could be an A1 or an A2 claim. It depends on how the interrogation, etc., came into the case. But yes, interrogation transcripts are definitely going to be something you want to look into, because a lawyer, we know that police tend to go a little more rogue, right, in interrogations. And so there's likely to be more inflammatory comments on those. So if you can get a hold of them, if they were introduced at trial, that would be an A2 claim. If they didn't come in at trial, you could possibly still have an A1 claim though. So those are the first two. And then the third and fourth claims, A3 and A4, they have to do with data. And these are the ones that, at least at my office, we're getting a lot of interest in from people who are impacted, because we all know the sentencing in California is racist. It has been racist. DAs are, racially charging people, et cetera. That's the whole point of the legislation. And so people are writing in and they're like, hey, I'm out of LA. This is my charge. Can you send me the data, et cetera? What I want to say is A3 technically is that you are charged or convicted of a more serious offense. A4 is around your sentence. So they sought or imposed a longer sentence. Those are two different things. So one is dealing just with your conviction and the other is dealing with your actual sentence. Both of those are going to be racially impacted, but proving that is incredibly difficult. And right now, unfortunately, we don't even know what data we should be bringing in front of the courts because we're still arguing about it. And so to the extent that your loved one may want to raise a disparity claim, is what they'll refer to it as, I would really caution them to wait, let some of this law roll out. I know that's really easy for us to say who are on the outside, but everyone is a little hesitant to make their client the one who decides whether the numbers are good enough or not. So especially if anyone's going to be filing anything on their own, wait for some of this law to come out for us to know what numbers are needed. For example, the big issue right now is you have to show, so say my client is Black, I need to show that that county overcharged Black people with attempted murder when compared to white individuals. And then there's this phrase, I need to show that my client is similarly situated. Okay, we have no idea what that term means right now. We are arguing back and forth about whether it's just criminal history, whether it's facts of a case, whether it's they have strike priors, whether it's about subsequent offenses that were charged with the crime. It's just a whole hot mess, as most things are when laws first get enacted. And so what I would really encourage family members and impacted loved ones to do, and impacted folks inside who can get their transcripts, go through, look for the coded language. We all know it. Try to put it kind of in a summary, explain it, contact an attorney that hopefully can look over your summary rather than having to look at the entire case, and focus your energy there. That's where, look at newspaper clippings maybe that were happening at the time. See if you can find articles on the officers who investigated your loved one. See if you can find news articles about, like, maybe, in one of our clients' cases, it was a year with a lot of anti-immigration legislation going through. And so we pulled what the political kind of tone was at the time and what a lot of the local DAs were running on for their platforms. And there was like very anti-immigrant platforms, things like that. So try to get the story and the context that went through your loved one's trial summarized, and focusing on the language portion and probably wait for the data, because one, it also requires experts, which require a lot of money, and two, it just leaves a lot of questions that are still unanswered, and I wouldn't want anyone going through it and kind of trying to cobble that together on your own. Lastly, as a personal aside, I really, again, this is a personal opinion, I really strongly discourage anyone from jumping on an attorney who has advertised to you. Just be careful about giving out your very precious money to lawyers. We already know there are a number that are like on a kick trying to write people inside. And so if your loved one gets a letter inside, I will say 99% of the time, that should be a don't even respond. So just be careful as this legislation rolls out. There will be attorneys who jump on that. And usually if they have a good website and a good flyer, they're not always the best lawyer. So that's just my personal, it's something that like really bothers me that attorneys capitalize on. So I just wanted to give that at the end. Let me just check the Q&As. So someone asked about, if you have a loved one who is Black and was charged with a particular crime, you had a hung jury with 2 Black members and retried by an all-white jury, that's going to be a really complicated situation. Yes, the racial makeup of the trial matters, and the racial makeup is not always on the record. So that is also something when you're compiling your summary to give to a lawyer to include. Because in a capital case, so if like someone is charged with the death penalty, then that is on the record. But for your regular non-capital cases, a lot of times we have no idea what the jury composition was. And so if you let us know who are all the players in the room, that your loved one was the only Black person, the only Latino person, whatever it might be, then there might be a different tone when we read the transcript. The other thing I want to say is that around the RJA, we talk a lot, obviously, about Black and brown folks because that's who is most impacted by this. But I also want to acknowledge that there are also stereotypes about white passing communities or just white communities, like low income from mobile home parks, etc., where like it's going to be a race-based theme that might go through a loved one's trial. So just keep that in mind. It's anytime you're like categorizing someone based on the color of their skin, you should be thinking Racial Justice Act. Obviously, as we know, though, in practice, that is going to be predominantly Black and brown folks. But we also, like, for example, a case that I'm working through right now, it's also around the race of the victim has a big impact. That's another thing that's not in the record, but if you can give that context is really important. Obviously, white victims actually are the driver of the disparity. It's usually the race of the victim. And that is information that for defense attorneys can be really hard to track down after the fact. So those are the pieces of information that would be most helpful, in my opinion, for you to put together and try to give a nice summary of to an attorney and to local county.
Hello, I'll pick it up from there. And Kayla and Brooke gave an excellent overview of the Racial Justice Act and recent revisions to it. I want to point out a few aspects of it that are some of the uncertainties about the future developments that we'll see in courts, and also encourage people in the audience to be thinking about ways that they can get involved, as Brooke had mentioned during her remarks. So as Brooke mentioned, there's 4 bases that establish a violation of the Racial Justice Act, which is encoded at Penal Code 745A. Now, interestingly, an appellate court in the state, in a case called Young versus Superior Court of Solano in 2022, distinguished between what it called the command, that the provision that lays out the violation, and the 4 enumerated grounds that are sufficient to establish a violation, which it referred to as means of proving a violation, but specifically stated that they're not necessarily that they aren't supposed to be read as themselves defining violations, but rather what are called means of proving a violation. So the actual violation is when the state runs afoul of the following, and I'll quote, this is 745A of the Penal Code: the state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. And then it proceeds with a second clause that says a violation is established if the defendant proves by preponderance of the evidence any of the following, and then it lists 1, 2, 3, 4 those means of proving the violation. So notable about this as a matter of statutory construction or the interpretation of the statute, the clause is the 4 enumerated grounds come after an if clause, not an only if clause. So it is possible for future courts to read this as laying out sufficient grounds for a violation, but not necessary grounds for a violation. This is important because we don't want to, foreclose the possibility that either broad readings of those 4 bases or even possible fifth unenumerated grounds could conceivably fit within the statute definition of in 45A. Now, when it comes to proving the violations under those enumerated grounds, the statute gives some guidance, which is quite interesting in terms of the breadth of possible evidence that could be allowed. So under 45 subdivision H1, the statute says that statistical evidence is relevant, but it's not necessary. That there doesn't have to be statistical evidence to prove a claim of to prove a claim that prosecutors more frequently sought or obtained convictions under A3 or under A4's more frequent imposition of harsher sentences based on either the race of the defendant or of the victim. That's interesting because it opens up the possibility that forms of testimony, either from lay witnesses or from experts, not limited to statistical evidence, might be admissible in proceedings either in the 745 context or in the habeas context of 1473 and 1473.7. So in addition to looking things that Brooke mentioned, like looking for news articles about law enforcement personnel involved, in addition to scouring the trial transcripts, things that one might try to do in coordination with the attorney representing the defendant or petitioner would be to find experts that could support the case, which could include social science statisticians, but it could also include historians, anthropologists, linguists, especially since coded language is a thing. Someone who's an expert on uses of racially coded language, and of course, non-expert testimony can also be relevant. The evidence code even allows lay opinions in some cases to be admissible if they are helpful to clarify a witness's testimony, or if they're rationally based on the perception of the witness. So encouraging defense counsel or petitioner's counsel to explore these avenues is perhaps something fruitful to consider. Also keeping in mind Brooke's caution that one doesn't want to create bad precedents by putting forth bad cases. So anyway, so if persons in the audience want to use a question and answer function to put forth ideas about how they might be of help to their loved ones' cases or their own cases, as the case may be, feel free to use the question and answer function for putting forth ideas about that, and we can address some of those as the webinar continues. And with that, I'll pass it over to I think Soo Young and Belle are next on the agenda.
Thank you, Eric. My name is Soo Jung Kim. As I said, I'm an attorney with the San Francisco Public Defender's Office. And I'm going to just give a brief overview of the work that public defender offices around the state are doing on the RJA. So there are, I think, 56 or 57 counties in California. I believe most of them do have public defender offices. And if not, then they do have a panel of attorneys who are appointed by the court to represent folks who can't afford to hire their own attorneys. Now, since the RJA went into effect, many of the public defender's offices try to gear up to bring claims under the RJA. Because it was a new law, and it was basically, we were all just starting from scratch with no guidance, but excited to litigate these cases. Public defender offices have been meeting on a regular basis to support each other and give each other ideas about how to move forward. Many of the major counties in California now have RJA, either RJA units or attorneys who are, specializing in the RJA. I'm happy to say. It's not a long list because, resources are hard to come by. But these are the counties where there is at least one person working on the RJA or a unit. Alameda, Contra Costa, Fresno, Kern, LA, Marin, Monterey, Orange, Riverside, Sacramento, San Bernardino, San Diego, San Joaquin, San Francisco, Santa Barbara, Santa Clara, Santa Cruz, Solano, Sonoma, Ventura, and Yolo. And so if your loved one has a case that originated out of any of those counties, my advice would be to get in touch with that office. If you are still, in touch with or know the public defender who tried your loved one's case, they might know the right contact at the public defender's office who is working on RJ issues. Or if your loved one has an appellate attorney or a habeas attorney, they might be able to find out who the right person is at the public defender's office to get in touch with. And so I encourage you to, reach out to the public defender's office to find out who is working on RJA issues, and then, partner with them, collaborate with them. If for some reason they can't help you or your loved one with the particular case, then they may be able to refer you to another organization, at least for resources. And so aside from public defenders' offices, I know of two other legal agencies that have resources and that you or your loved ones could reach out to, not necessarily to represent your loved one in an RJA claim, but at least to give you information to help you link up with somebody who can represent your loved one. One is the Office of the State Public Defender, OSPD. And so OSPD is kind of a, clearinghouse for RJA litigation. Their job, however, is not to provide direct representation to any individuals, but they are there to provide legal support to attorneys who are working on RJA. They do have an attorney of the day program. And what they can provide, like I said, is they can link you up, or your loved one, link them up to other attorneys who could, provide representation. So let me put in the chat, let's see, the email address. And that email address is contact, CONTACT.AOD for attorney of the day at ospd.ca.gov. So please make note of that. And then the other organization, which you'll hear from next, is the University of San Francisco USF Racial Justice Clinic. And you're going to be hearing from Belle next about what they can do to help you out in this situation. So I'm happy to take any questions on the chat or in the Q&A about legal organizations. Otherwise, I'll turn it over to Belle.
Thanks, Sujung. Hi, everyone. Like I said, my name is Belle Yan. I'm an assistant professor and supervising attorney here at the University of San Francisco Law School. And I work specifically in the Racial Justice Clinic. And the core of the Racial Justice Clinic is to defend and advocate for those who've suffered from discrimination, marginalization, and oppression based on race. And the way that we're involved with the RJA is that we're acting as one of the clearinghouses for folks who believe they have an RJA claim. So we encourage you, if you know that your loved one were represented by the Public Defender's Office or the Alternate Defender's Office, to reach out to those offices first, because they're the ones who are most familiar with your case. But if you were represented by an attorney who was appointed by the court, or maybe an attorney who no longer practices, we welcome you to reach out to us to request an intake form. I'm not sure if I'm able to just provide that information to everyone. So if somebody wants to ask me a question of what our contact information is, I can send out our address and our email address. We are mostly looking through these intake forms, seeing if we can figure out where exactly where we can send your case to or who we can refer you to. We are taking a very small handful of cases ourselves. We are a very small but mighty team. There's only about 4 attorneys here with a handful of students every semester. So our capacity is small, but we have been, and we are going to continue reviewing the intake forms that we receive to make sure that we can try to refer you to the right people if we're not able to take your case ourselves. And the form is about, it is kind of long. It's 11 pages. Feel free to, type your answers and to handwrite your answers. The person who's filling out the form does not have to be the person who is incarcerated or is the one who is directly affected by the RJA claim. It could be a loved one or a community member who's their advocate. But we're happy to send the form over to you once you've reached out to us to get that. And I'm happy to take on any questions, and I'll put that contact information on our QA right now. Thanks. And I'm going to turn it over to Cecilia.
Hi, everyone. Thank you for having us. I just wanted to talk briefly about the work that we as community members could do and as family to support our loved ones who are going through this process or who are thinking about it or just kind of toying with the idea of maybe pursuing this motion for your loved one's case. So Silicon Valley Debug is one of the organizations that works with families, along with Oakland Participatory Defense Hub, that works with families who are going through this process or thinking, who are going through the process in the criminal justice on itself. And just because of the nature of that we've been doing this for so long, so many families that we're now supporting that we supported 10 years back are now considering whether an RJA motion would work for their loved one. So just wanted to say some of the things that we could support you as community organizers is kind of just help organize those thoughts. As Brooke was mentioning in the beginning, you might have like a lot of old records or maybe not, but we can help you navigate the systems of trying to get them for your loved one, or if you do have them, sitting with you and just kind of reading through some of those sections where you felt that gut punch in your stomach, because we had families that have come and to our weekly meetings and said, you know what, that just didn't sit right. For example, one of the phrases one of the families shared was like, well, he grew up on the wrong side of the tracks. That might not feel like a lot, but when you start exploring the context in which that phrase was said during trial, then it might be worth kind of exploring. So we might be able to help you, kind of just sit with all those documents, or help you get those documents. As Kayla mentioned, I think she said in the beginning, come to a meeting. We have weekly meetings for families, not just going through the RJA case, but that's definitely one place where we could toy with that idea and just create a plan step by step. Every week, come in, we do one, we check one thing off the list. And we have about 13 organizations in California that could sit with you and help you do what I just described for your loved one's case. So I think Kayla's gonna put it in the chat. We have a network in California, and you could look us up, participatory-defense.org. That's our national list of organizations, but you can look for the ones in California. They're right there for you all to kind of just take a look. And if you can't find one in your specific county, because as it was mentioned, it's very specific to the county that your loved one was convicted out of. So if you can't find a organization in that listserv with your county, feel free to email me. And I think she's gonna put my email as well, or it's in the site too. It's Cecilia@siliconvalleydebug.org. Thank you. I think we're gonna discuss now some examples of what a successful RJA claim looks like, and some of the unsuccessful ones.
Hi, it's Sue Jung again. So I'm going to talk about a case that originated out of our office in San Francisco that had a level of success. So one of our attorneys had a case where her client was charged with illegal possession of a firearm. This is what happened when he was arrested. He was parked in this car. He was dropping off, he and his wife, who was the passenger, were dropping off their teenage daughter at school. They were legally parked. They were just going about their business. The client was Black, and so were his wife and child. A white police officer who happened to be driving by decided to check the client's license plate on his computer, and it came back to a different car, not the car he was driving. So based on that, he pulled up behind them and went up to the client and said, can I see your paperwork? Eventually, after discussion, the client was able to produce paperwork that said they just bought this car a couple of weeks ago. And so the officer was satisfied that the car wasn't stolen or anything. So at that point, the encounter should have ended. However, the officer decided to get their IDs and do a search, and found out that the client was on parole. Then he searched the whole car, he searched everybody, and found a firearm. So we brought an RJA claim because when we read the police report, it said the reason he decided to check the license plate was because the car was parked in a high crime area, quote unquote. And that was the only reason. So we brought the RJA claim saying that the detention was based on race, because we had consulted an anti-racism expert who was a man who trained as San Francisco Police Department in anti-racism and how to, make decisions not based on race. And he gave us a declaration saying that police routinely use high crime area as like a racist dog whistle, mainly referring to Black communities. And so we included that in our Racial Justice Act claim. The judge denied our motion, finding that he believed that the police officer never saw the race of our client and his family before checking the license plate. He also said things like, well, in fact, it is a high crime area, so it is true that it's high crime, so the police officer was justified. And then, when we lost, we brought we filed a writ to the Court of Appeal. And 3 weeks ago, the Court of Appeal agreed with us and found that the judge had made an error in denying our motion. And for us, what was vindicating on several levels. First, the Court of Appeal recognized that this type of claim, in which a police officer stops a Black person for basically no reason at all, no legitimate reason, that is something that's recognized by the court that we could bring under RJA. Secondly, the Court of Appeal stated in order to pass the initial threshold to prove an RJA claim. So the hearing that we had in front of this judge was what we call the prima facie hearing, which is the first step in proving an RJA claim is to, put out certain facts that showed that, it's possible that there's this officer violated the RJA. And we put out, the facts. We put out that he stopped him because he was in a high crime area, no other reason. We had the anti-racism expert talk about the high crime area being used by police officers as a racist dog whistle. And we also had statistics that showed San Francisco police stopped Black people at a much higher rate than white people. So we had that data. And so the Court of Appeal said, as long as we present data that shows that there's a possibility that this was a RJA violation, that's all we need to go on to the next level, which is the evidentiary hearing. So at that hearing is when we actually, present witnesses, present expert testimony to prove that this officer did in fact violate the RJA. But at the initial level of the prima facie stage, we don't need to prove, we don't need definitive proof. So the reason why this is an important decision is because now anybody who brings an RJA claim, it will be easier for them to get past the initial threshold stage. And the court said the judge is not allowed to weigh the evidence or decide who they believe. In our case, the judge said, I believe the officer. I believe him when he says he didn't see that the client was Black. Because of this decision, the judge cannot make those determinations at the prima facie level. And so it will make it easier for all of us to, move forward to the evidentiary hearing. And so what the Court of Appeal did in the end was they kicked the case back to the trial level for a new hearing, and for the trial judge to, redo the entire hearing and decide whether we can move forward to the evidentiary stage. So the final thing I'll say is, even though the case I'm talking about, was at the trial court level, those of you who have loved ones who have, who are serving sentences and have post-conviction claims, RJA claims, this case would apply to their claims as well. Because the thing that we need to do is get back into court on your loved one's claims. And once we get back into court, those same, the law would apply to bringing those RJA claims, and this case should help you. So that's the case is called Finley versus Superior Court. And, I'd be happy to share the opinion. I'd be happy to answer any other questions that you have. Thank you.
And then, thanks, Sujong. That was it was a very big win that we all celebrated. Even those of us who were on the fringe of the work. I also wanted to just give a few anecdotes around also how we would expect this to normally play out. What we are seeing with a lot of what we would call RJA wins are charges being downgraded or offering a different sentence, maybe dismissing an enhancement, things like that. So I just want to point out that if there is a situation where RJA claim is raised, maybe your loved one's back for another resentencing, to strike their nickel prior. Sometimes the RJA litigation won't be flushed out in court, a lot of things aren't, right? It might be kind of backdoor conversations, etc. So make sure if you feel like there is an RJA issue, but it's not getting talked about in court, ask the attorney if it's coming up in negotiations with the DA, if it's coming up, maybe when they're in chambers with the judge, etc. While we are having some great wins, we also unfortunately are having some unsuccessful ones. I wanted to highlight one that recently came out. It was a published appellate decision. And the situation was the defendant in the case was a Black woman charged with 2 counts of premeditated first-degree murder of her parent. So obviously an emotionally charged case, because people have a lot of feelings about that. And so the judge was clearly a little bit amped. The defense attorney tried to cross a witness, so ask them questions that made their testimony look bad in some way, and supposedly used a piece of evidence that the judge had said couldn't come in for one reason or another. Long story short, judge gets really pissed off because the attorney, who is also a Black woman, corrects the judge, ends up being right. And then the judge from there on escalates, right? It's something that we've seen play out all the time. The attorney tries to call the judge on their behavior and say, you're kind of yelling, you slammed your hand down on your desk while we were in front of the jury, you're rolling your eyes, making all of this record as to how the judge is responding. But the attorney did not specifically say, and I'm invoking the Racial Justice Act. And so the appellate court said the issue is waived, which means we can't raise it on appeal. That doesn't mean, though, if they can't go through the habeas procedure, right? So you can raise it on direct appeal. We're arguing in the trial court or on habeas. But it is just a good reminder if any of your loved ones are currently going through the system, or if they're going through the system in the future, a lot of this is going to fall on, unfortunately, folks of color, to educate the courts, to call them out on being racist. And it's obviously impractical, right? To say, hey, judge, you're being really rude to me, and I think it's because I'm Black, and you have an issue with that. Now I'm going to raise an RJA motion, and hopefully you'll come to your senses, is mind-blowing. Like, a judge is not going to be like, well, you just filed an RJA motion, and now I'm really going to think about my internal biases, right? They're going to double down. I'm not being racist. How could you call me that? Blah, blah, blah. This is an issue we're heavily litigating, but it's just one of those really unfortunate reality checks of everyone who understands implicit bias saw what was playing out, could name what it was, but a lot of these decisions are going to come down to judges who don't understand implicit bias, or are going to come down to attorneys who either don't want to call it out because they have to keep practicing in front of this judge all the time, or who maybe don't have the language, don't feel safe to do so, or just don't know it. And so that's one of our big issues that we're flagging right now, and something just to know. That doesn't mean, like Sujong was talking about with their case, they lost, they go up, they won, they go back, they might suffer another loss and then go back. This is going to get litigated a lot. And so your loved one should also just prepare for a lot of back and forth in the courts, and likely a lot of up and down with the courts. But yeah, it's just being realistic that we are in front of judges that tend to be white, tend to be older, and tend to be very poorly educated when it comes to issues on bias. I think those were our kind of examples, so to speak. One other thing actually that I wanted to mention, I had a case, we ended up settling on a different issue, but I briefed it. And this is, to me, like, it really shows how families can be helpful. I had a juror who made some random reference to growing up in Detroit in the 70s during like white flight. And I was like, okay. And they were talking about the politics, and he's like, oh, well, I think the mayor kind of like fueled some of the racial tension. But that was back in the 70s, and I've moved on. Well, when I dug into that really weird political reference, that mayor was the first Black mayor of Detroit who ran on integrating the police force after a series of incredibly violent anti-Black scandals by the police force. This really weird random comment with a Google search became a Racial Justice Act claim. And something that I had read it 6-7 times, hadn't thought of it. Another colleague was like, who is this person? I was like, good point, I should look into that. And then it ended up being this big issue that we briefed. And so also, when people are referencing any sort of political figure, any sort of legislation, just anything that you're looking at and you're like, I don't know what this is, like, Google is your friend here, and providing that context to the attorney can be helpful. Or maybe you have like a loved one who grew up in Detroit in that time, and you can like call them and be like, hey, what do you think this reference is, etc. But that would be a great example of how like my argument had very little legal background to it. It was mostly Google. And so you will have those kind of situations that come up as you're reading through your loved one's transcript, where it's like, that seems odd, let me look into it. So that's just another example. And then I think, Cecilia, back to you. Is that right?
Yes. Thank you for sharing that example, because that's really what how families could really support their loved ones throughout this process. In Santa Clara, we've had some interesting cases, not specifically with the newer version of the law that's becoming retroactive, but with active cases that I'm sure are going to bring up some similar situations once 2024 starts rolling in with the retroactivity. So some of the ways that you as the family member could help your loved one who's currently incarcerated is really just kind of step one is just reviewing those four criteria of the RJA and seeing you know, which one would best fit my loved one. And sometimes that's going to be a hard thing to do. But the first thing is to talk with your loved one and just ask them, is there anything particular during your trial that you remember that you had that gut feeling where you said, damn, that comment as Brooke doesn't kind of sit right, or the way they were emphasizing a certain word. That's a great start for you and your loved one, because then you can start getting the transcripts of that situation. If it pertains to an A1 or an A2 claim. Because as Brooke mentioned, the data component of it, it's really hard. So right now we just want to focus on things that you or your loved one remember that happened during trial. As mentioned before, it's very particular to your county. So some of the things that we as organizers help you do, a lot of it is now reliant on computers. So we could help, you know, write that email for you, or write that email to the court clerk, sit with you to review all of those documents, help you get the abstract of judgment. That's one of the first things that we ask families. Like, hey, what was the convicting county? Do you have any paperwork that could help us get this off the ground? So, you know, in Santa Clara, I don't know how other abstract of judgments look like, but for the families we're supporting, in Santa Clara, it'll say the courtroom that they were sentenced in, it'll say the reporter, the judge, all of that great juicy information that we could start digging into. So once we got the abstract of judgment, now we have the courtroom, now we have the reporter. So then we do that email to try and get those transcripts, those sentencing transcripts, you know, all of that stuff that is needed to start that evaluation. And then we help families also kind of navigate all of that post-conviction world, because I forgot who mentioned it, but an RJA motion, it's not kind of, it doesn't live in its own bubble. It could come in, you know, if your loved one is going through a 1437 petition, the felony murder rule, or if they're being considered for another form of relief, it's a way to bring in an RJA motion as well. So if they're already going through one avenue, this could be another avenue as well. So that's always, you know, good to know. We're always inviting families to our weekly meetings. Like for us in San Jose, we have 2 meetings just to be able to support, you know, the number of families. We have one on Tuesdays and one on Wednesdays for families to come and, you know, we do what I mentioned earlier, that step by step. We're chipping at it one week at a time, because as Sue Young mentioned with the other case, it's not a win right off the bat. You got to continue working on your loved one's case. What else? We got participatory defense organizers here. Like some of the, you know, I don't want to get too much into the weeds because every case is very specific, with you know, with your loved one's convictions and all of that. But in a nutshell, that's what we do. In Santa Clara, we do have an RJA attorney in the public defender's office, so we're able to kind of vet these questions or have an exploratory conversation with her regarding the possibilities for an RJA claim. So for example, one of the cases that we kind of flagged for her was, it was a DUI stop where the person was stopped because he was playing Spanish music too loud in his car. So he was stopped, and it's a very notorious San Jose spot, the east side, where there's a lot of Latino presence. So I know that context. So I was helping explain that context to the RJA attorney as well. He was stopped because he was playing corridos. So the police officer makes a comment and says, oh, you know, you must deal drugs because you're listening to these corridos, was like, what? Like, that's insane to hear that. You know, like, oh, you know, if you like corridos, that's an implication that you are using drugs. Anyway, they go forward, search his whole car, don't find anything, but now he's left with a DUI, because he was stopped just for having his loud music, and then he was, you know, further questioned and insulted for the type of music that he was listening to. So that's kind of in the exploratory stage that we help bring forward to the RJA attorney. And that was really just from the conversations that we're having on our weekly meetings, where like, hey, I'm facing this charge, but the charge itself, you know, it doesn't feel right how that kind of transcribed into the charge. But you know, we're here to throw the noodles against the wall and see what sticks in terms of your loved one's situation. And we're here to problem solve, think with you all. And I'm sorry I have to keep looking away, but I got a 1-year-old who's like throwing it down in my working space here. I don't know if Oscar or Kayla or Rocky, you guys want to add a little bit more regarding what you guys do in Oakland?
I see Rocky's hand up.
Yeah, I was just wanted to mention too, because one of the things that, and I saw it in the chat, everything that you were saying, like it's not what we do, but being able to go over the transcripts, right, which can be very frustrating. It's very long. Some people's are thousands and thousands of pages, and it can get discouraging. So one thing we do is encourage them to do a little bit at a time and look for terminology. Like because like there's certain terminology that you hear a lot that I'm still kind of waiting to see if it like street terrorists. We're always called, a lot of times they're calling us like terrorists, they're street terrorists. Is that going to be enough? One of the ones that I seen in the chat, one of our participants, but I think it's a strong case, but I just want to talk a little bit about that one, is her son is white. You look at him, you think he's white. And then he's in court, and she did an amazing job, his mother, right, going through the transcripts. And like 20 times, I believe it was, and she could add on, they keep mentioning him as African-American. Like you keep mentioning him as being African-American, and I can see one time or whatever, but what does that have to do? Because it's not a racial impacted case. It's just, it's a case, it's a shooting. I think it was a drive-by shooting. The car was parked, but to keep saying that someone's African-American that many times, you're trying to influence the jury. All white jury, Placer County, you know, they're racist, right? So like, to me, I already know you're trying to use that against him, because why would you even say that? Because he looked at all. He just looked white boy. And then, but obviously are saying it for those reasons. So that's one of the ones that we've been working on, that I think has a lot of merit, but again, waiting to see, you know, how it all plays out. Really looking at the terminology. I remember when I was going to court myself and I was convicted of murder, my attorney just dropped it. He defended me for 1 hour. I was prosecuted for 2 weeks, didn't make opening statement or nothing. And the first time I ever talked to him, the only thing he told me was, why do you talk like you're black? Right, that was the first thing. So like, he obviously didn't like me. And like, I wonder about things like that, because that has to happen to a lot of just, you got so many racist attorneys, and their natural their natural prejudices, they gotta come out, that, you know, they come out. And it could be through the tone of voice, the way you say something, the way they use, the way we talk slang. Like, that's a lot of things we look at in the transcripts is, we have, you know, growing up in areas, we talk with slang, but they use it against us like it means something that it doesn't. Like, oh, he said this to him, so his intent was to assault him, you know, and stuff like that. So I don't know, we're kind of curious to see, like you said in the beginning, wait and see approach. And then once we find out what these are, to get people back in court. Well, one thing that I wanted to ask too is, would it be good to get, because the attorneys are cheap. I mean, not attorneys are cheap. But like you said, attorneys, when they come at you, like, to stay away from them, right? And I agree 100%. What about getting, because I know it's a lot of work, is to hiring, what's it called? Hiring, private investigators, because, you know, it's a little cheaper, and maybe hiring a private investigator to dig through a lot of that stuff as well. I was just thinking of that when you said that about the attorneys.
Yeah, as my like general caution against spending money. A private investigator is a little different, because you're right, it's not the same financial investment. And sometimes you do, it saves the emotional labor, right, of the loved ones having to go through things. I would still be cautious. I would pick someone who is from the community that is impacted, so who shares an identity with your loved one who is inside, just because then theoretically you hopefully will have to educate them less on kind of what you're looking for, etc. So I think that might be something worth looking into, or I at least would not have as much knee-jerk caution about as hiring a lawyer. But also generally be cautious of anyone who offers flat rates. So if they're like, I'll do your case, like even if it's an investigator, like I'll investigate for $2,000, or a lawyer who's like, I'll handle it for $5,000. Anyone who's giving you a flat rate, not usually a good sign. It should be like a by hour, because they don't know in the 30-minute consult like how long things are going to take. And Rocky, thank you for mentioning the case that was in the chat. I wanted to emphasize that, for example, so like the first presentation of that fact, of that case, did not include that the impacted individual passes as white, even though they are biracial, right? That is not a fact that will show on your record. And so adding that, and then all of a sudden, a judge identifying an otherwise white passing person multiple times as Black really shifts the factual reading of a case. And that's where I would say spend a lot of time thinking about what is not on the record. Anyone who maybe had a translator, for example, translations are terrible in court. They are messed up all of the time. And so if you're like, oh, this got translated as X, but how he would said it was Y, that is all information that's like really important to know, will not appear anywhere on the transcript. It is only the translation spoken in English that appears. So those are components that are also really important. Or sometimes if a reporter doesn't know how to spell a word or say like whatever it might be, they will like whitewash the word or the name or the reference. So also that sometimes like we get it and we actually don't know what it means because they didn't type the right word. So like focusing on things like that as well. But this is where spending some time and really being like, what are all the facts that are in your head that make it so that when you were there experiencing your loved one's trial, you're like, nope, this is not right. Like this is race coming in. What do I need a middle-aged white man to have in his head? All of the context, all of the background, all of the lived experience. What do I wish was in his head? So when he reads this, he reads the same thing. And I say that just because that's predominantly the judges we're in front of. But I also want to emphasize defense attorneys are not immune. So if your loved one had an attorney who said something racist, who just seemed racist, whatever it is, we are not immune, and attack us just as hard as you would attack a DA. Like I'm a firm believer in that. And most of that will not be on the record, right? Because of client confidentiality. So getting your loved one to really put all of that on paper. If you had interactions with that attorney, if you emailed with them, if you texted with them, you know, all of those things would matter in showing that that attorney was racially biased against your loved one. So yeah, I just, Rocky, as you were talking, those things like popped into my head that I wanted to note.
Thank you, Brooke.
I'd say Rocky mentioned what I was thinking of, but kind of just reiterating, just especially like think of everything you can when it comes to like if you think your loved one's case was an RJA case, like it does, like Rocky said, it does take a lot of work, just like fine tooth combing through the transcripts. But if your loved one, or even if you even think that this is an RJA case, like definitely like take that time to go through it, because laws are changing, things are passing, and it doesn't hurt to see if your loved one it qualifies for it. So that's what I would add to it.
I did want to ask this too. Remember when you were saying how when they say you file, you find something, right? And then it's like the first phase, and then after you go there, you get into the evidentiary hearing. If you make it to that part of the evidentiary hearing, is that a space where you could bring in, they look at the totality of your case, like say you could bring in try to get a gun enhancement taken off, or you got to go further than that? Because you know, if you get your case taken back, say like for a 1 year prior, they look at the totality of your case, and now you can have other things taken off. Would it be at that level if you get an evidentiary hearing? Would that be possible there, or no?
I don't have enough expertise in post-conviction relief work to know whether you can raise the RJA claim in that situation.
We think you can. Debatable, right? That's where yeah, if you're going back to strike a 1 year or nickel prior, etc., we are arguing that once you're back in the trial court, so right, the appellate court says, okay, go back and deal with this, you now can file a motion in the trial court, is what we are arguing. Whether they will take that or not, we will see. And then the prima facie hearing, or prima facie showing, really, which courts are turning into full-on hearings, as Sue Jung was talking about, that is supposed to be like a low bar where you're like, here's basic information, assuming it's true, is there a likelihood? And then the evidentiary hearing would be like bringing in your expert witness who's going to speak about dialect, or who's going to talk about coded language, or is going to talk about cultural references that were, you know, twisted against the client, whatever it might be. Right now, the world of relief for the RJA is the sky's the limit. So if they find there is an RJA violation, you make it through your evidentiary hearing, the court says you've met your burden, I think race played a factor, we don't know. Theoretically, you could ask for a new trial, you could just ask for a new sentence. Like, there's no limit really on the relief yet that can be asked for. It is, you know, when you're going through the trial phase, it's a lot more clear cut. They're like, okay, we'll dismiss this enhancement, or we'll plead you down, or whatever it might be. But post-conviction wise, we don't know. A good example of this is there was a gentleman who he received a very lengthy sentence as a child. He won on appeal. The case is People v. Heard, where they said he should be entitled to receive a new sentence. He raised an RJA claim when he went back for his resentencing. And because of the RJA claim, which was like a disparity in how they sought these really lengthy sentences for children, the DA said, okay, never mind, you can go home. Like, like we'll just plead you out to time served. That would be an example of an RJA case impacting the outcome in a very different way than like how we would normally handle a case. So we'll just have to kind of wait and see what the district attorneys do. Some will want to spend all the money and litigate, and some will be like, okay, what can we do so that like you stop coming back? And I just want to reiterate that like this is the time to trust your gut, like 100% with the RJA. Like I know a lot of times lawyers are going to be like, yeah, I know that feels weird, but this is what we do here. This is really a time that like if it felt wrong, find a way to get that on paper as well as you can, and try to get to an attorney who will read it.
And there was a question and answer portion, and you guys have been answering it really fast on the panel, so thank you. And audience, if you do have any more question and answers, you want your questions answered, just type it in there or bring it up.
Just to sum up tonight, California Racial Justice Act and its progeny are groundbreaking legislation aimed at addressing and redressing racial discrimination in criminal cases within the state. It acknowledges the profound impacts of systematic racism and aims to ensure that race, ethnicity, or national origin do not influence trial outcomes and sentencing. Challenge their convictions or sentencing by providing evidence. Excuse me, my computer decided to make noise right now. Defendants can challenge their convictions or sentences by providing evidence of racial bias. This evidence can come in the form of explicit racial bias, statistical disparities, or other types of discriminatory effects. The Act allows challenges based on evidence that can be shown in various ways, as Brooke so nicely laid out for us. This includes policing, including racial profiling, or the systematic under-investigation or under-prosecution of crimes based on race or ethnicity of the victim. Additionally, the Act can be applied retroactively, allowing people already convicted to file claims if they believe racial bias influenced their case. As Eric pointed out, as defendants begin to challenge these convictions under the RJA, the legal precedents are going to be made, and they can establish significant further precedents and clarify the Act's scope and potentially change the landscape of the criminal justice system. The Public Defender's Office, racial justice clinics, and participatory defense hubs are really encouraging the systematic change that this legislation can provide. So, as thoroughly discussed by Sujing, Belle, Cecilia, Rocky, and Kayla, by forcing the system to confront and rectify instances of racial bias, the RJA can push for systematic changes from the way law enforcement operates to prosecutorial practices in jury selection. So while it is certainly not the end of the tunnel, the California RJA is a significant step towards rectifying racial bias in the state's criminal justice system. Its impact, will likely extend beyond individual cases, influencing broader conversations about racial justice and potentially inspiring reforms in more jurisdictions to come. I want to thank all of our panelists for taking the time out of their day to share their expertise with us this evening. And additionally, we want to thank everyone who spent their evening with us to learn more about this important piece of litigation. Excuse me.
Awesome, thank you. And I just wanted to add, I did leave some information in the chat. There is a Racial Justice Act FAQ form that our folks at Ella Baker Center put together. It's wonderful. If you haven't seen it, I definitely recommend you checking it out and sending it to your loved ones. And also, Belle did share that RJA intake form, so that is also in the chat. And then you all will also have access to this recording and the forms that are left in the chat as well. And thank you all to our wonderful panelists for spending the evening with us.
Thank you, everybody.
Good luck, everyone.
Thank you.
Thanks, guys.
Bye.
Thank you.